the development of case law relating to motion pictures, the use of copyrights in financing for movies. And then let's look at trademarks. How did trademark mortgages, how did trademark mortgages in this particular case here, did it develop in the same way that patents and copyrights were used as security in mortgages at all? Now, trademarks is very interesting. Back then, the businesses and the courts recognized there's some things about trademarks. That they recognize that you cannot separate the name of a company. This is the old thinking. Okay? You cannot separate the name of the company from the business itself. And so back then, the court said that, you know what? You cannot separate the name of the company, the name of the products, the company making them from the actual business itself. And so therefore they say that trademarks, unlike patent and copyrights, we cannot allow, back then, we cannot allow trademarks in and of itself be used as security in financing. Because they say the trademark only have rights based on use. And so therefore it's intertwined with the businesses. And so the court in the old days, when they look at trademark mortgages, one particular case, the court looked at it, trademarks back then in 1884, they say that trademarks, we won't allow trademarks to be sold without the businesses at all. And so because trademark could not be sold without the related business, therefore trademark could not be used as security without the business at all. That was the old thinking in 1884. And in fact that they say that the only way that we will allow trademark mortgage to occur is that, for example, I'm a trademark owner. Let's say that I own the name XYZ back in 1884. And I have a business selling products using the mark XYZ. I need financing. I come to you. And the fact that the law at that time say that trademark could not be sold, leave alone mortgage. So the only way it can happen is I come to you for $50,000 loan. That's a huge amount of loan. Back in 1884, of course. And so the only way to occur is that the court say that the mortgagees, they have to come to my company and operate my company, has control of my company. Now, that's not good for me as the mortgagor, because I don't want people to come in and run my companies, because I know my companies better. I know how to run my companies better than somebody else to come in, and particularly if somebody else merely a lender, merely the banker. I don't want them to come into my business and take control and run my business. So in the early days, trademark mortgages was not common. Was not common because of that limitation when you trace back. So then, the whole process was so cumbersome. I use a term here, and that's why it was very limited. So what I have presented to you then, the development of patent mortgages, and you saw the cases 1845 and 1891. I showed to you copyright mortgages at the same time that patent mortgages was going on. And I showed you that in terms of trademarks used as mortgages was very limited. So that's all in the earlier history. Well, let's move a little bit forward for a second. Okay? And so then let's enter World War I and World War II. Let's move forward. Okay? So what happening is then, the end of World War II, we all know, okay? The United States in the 20th century built itself as the superpower, world superpowers here. Okay? And if you look at the development of law during this period of times here, when the U.S. was experiencing significant economic growth and financial growth, well, right after the war. What you see here is that we all know there's a concept and there's a movement called the Golden Age. I call them the Golden Age of legal realism movement in the United States. At that time, just right after the war, okay, this huge legal realism movement, particularly headed by some of the incredible famous legal scholars of the 20th century of legal realism movement. I have the pictures, these pictures here, two very, very important legal scholars relating to the development of the Uniform Commercial Code, of the commercial law, of contracts law. They are Carl Llewellyn and Grant Gilmore. These two giants in the legal realism movement, what they did, they observed transaction. They don't create law from up here. No, no, no. They observe realism, okay? Real, something going on, real. They observe all the transactions. They talk to lots of people, all the transactions. And then they essentially working with different stakeholders. And when they drafted law, particularly relating to secure transaction law, many of the transaction was already occurring, and they making sure that the law reflects those transactions in reality, and also identify what are the issues here of concern and what do the stakeholders want and why. And then this enormous process went on. And you saw then in the legal realism movements then the creations of the U.S. Uniform Commercial Law. And for the purposes today, I will focus on Article 9 of the UCC itself. And Grant Gilmore is essentially the grandfather of UCC Article 9. What it means then, they look at the mortgage law relating to chattel mortgage, and they say that it's so obsolete. That law is obsolete. We need to modernize to reflect the realities itself. Right? So that's what they did. So moving from the old mortgage law into a concept that's called secure transaction law. What it means that all those devices, security devices, for example, hypothecation, mortgages, warehousing, trust receipt, conditional assignments, all those security devices, they say that if you look carefully, not at the names, but look at the substance. Look at the substance underlying different security devices here. What it really means that we have a transaction in all these complicated security devices. What it means is really simple. We have a transaction. One side wants to borrow money or want to receive credit. The other side willing to extend credit, provide financing. And the other side would like some assurance in whatever form it is, an assurance. Both parties are going to enter into an agreement, and that if this side over here cannot make the obligations, the other side will have remedies. And so therefore, take all these complicated, confusing, overlapping security devices, put all of them in one legal framework called secure transaction law. Okay? And that's what they did. And that became the blueprint for UNCITRAL projects. Came in much later on. But these men came up with that idea. And so then, what they did then, let me summarize it. The legal realism movement allowed the birth of commercial transaction law in the United States, particularly secure transaction law. That was going on. Well, what's happening to the intellectual property law? Well, guess what? We cannot just allow the commercial law modernizing it without modernizing the intellectual property law. And so then Congress decided that it's time, around this time, to modernize intellectual property law. How so? So the Lanham Act. The Lanham Act, treatments of trademarks, 1946, brought trademarks law into modern time and slowly opened the doors for the recognitions that, guess what? Trademarks, you can sell trademarks without the business. Separate it. If you say you're going to value the trademark, then you have to allow alienability. And you have to allow that the trademark with the goodwill to be sold separately from the business. All right? That's very important. So the development of modern trademark law recognizing that, which means if trademarks can be sold separately from the business, and of course trademark can be used as security in financing. And so patent law, major change. At the same time, legal realism movements going on in commercial law. The major overhaul in patent law in 1952. We have to modernize patent law. If we say that we think that patents important, the law gotta reflects the reality. And so the modernizing of patent law in 1952 was so significant. Okay? So then to encourage a clearer review of inventions. Okay? And you can see then a clearer, people know what the rules are, and we see that particularly with section 103, 35 U.S.C. 103, relating to non-obviousness. And so you can see then more patents, because everyone knows what's required now. So you can see then the more patents was issued. And at that time, if you look at the 50s, a lot of innovation was going on in the United States. Okay? And so patent law hand in hand to go with that. And then what's happening in copyright law? Copyright law, how do we bring copyright law to the modern days? Okay? So copyright law to the modern days, the major revisions, it took a long time. Major revision occurs in 1976. So what I'm trying to show to you is that legal realism have transformed security devices into secure transaction law. At the same time, IP law have to be modernized. So you see all the movements in IP law from in trademark, patent, and copyright law. So these two now are going at full steam. They got to cross. Okay? They're going to cross. Mm-hmm. So I'm going to skip because there's a lot. I don't have enough time, so I'm going to skip. Mm-hmm. So essentially is that the end results of the two powerful forces going on is that you see trademarks copyright patents are used in secure financing. And what you see then, the developments of case law during that period of time up to the present, you see in the movie industries, so you see the case law reflect the transactions using copyrights as security in the movie industry. That has become very, very common. And then what's interesting that Australian government, remember that Australia became a magnet for movie makings in Australia. And so therefore, Australia then reformed their law relating to secure transaction and then the use of copyrights in movie financing in Australia as well. So what I'm trying to say, when the ideas percolated and expanded in the United States, other countries, they also copy the ideas itself in terms of copyrights in financing. And then trademarks, lots of cases, the use of trademarks in secure transaction itself. Remember, I started out talking about the Constitution because the Constitution stated that Congress have the authority to legislate patent and copyrights. And then under the Commerce Clause relating to trademarks, and we saw the Lanham Act. And so because IPs are creatures of federal law, but secure transactions in the United States, secure transaction is a creature of state law. And so therefore in the United States, a number of cases in the 80s and in the 90s that we have to address is that whether if the lender lend the money to the IP holder and the lender take a security interest in the IP, must they, the lender, follow federal recording system or must the lender follow the state recording system? Because secure transaction is state law. Okay? But these are the problems unique to the United States. You don't have to be worried about it. If you have just one set of law in this country, then that's not an issue. But in the United States, we have federal and states. We ran into a whole host of legal issues relating to, is that federal law or is that state law? And we, the United States, have to address that issue because why? Because if you, the lender, if you register or record your security interest in the wrong office, what will happen to your rights? When another lender came along and they also provide financing to the same IP holder, and if when they provide the financing to the same IP holder, they conduct a search in the office, and then they did not see the first lender's name anywhere at all, and which means this second lender makes